SJC-12903, Psychemedics Corporation v. City of Boston.
And we'll hear from Mr. Bagatti, please.
Thank you. May it please the court. I'm Peter Biagetti on behalf of the...
Your Honor, if I may, the city is the appellant.
Oh, I have that completely. I apologize, Mr. Fitzpatrick. I had it conflated on my paper. Thank you for that. And we'll hear from Mr. Fitzpatrick.
May it please the court. I'm Tom Fitzpatrick. With me this morning is, although socially distant, my colleague Courtney Simmons. It's our privilege to represent the City of Boston in this matter, which is a lawsuit that was brought by a vendor to the city, Psychemedics, seeking to avoid its contractual obligations to the city, including its obligation to indemnify the city for claims arising from negligence of Psychemedics. Now, a common thread that runs through Psychemedics' contentions and theory of its case, it can be found in its motion for summary judgment below and in its brief to this court, is the contention, for example, in the motion, that the city breached the indemnification clause by not allowing Psychemedics to assume the defense of the lawsuits. That's asserted again in its brief, and in their brief, they go so far as to say that the city prevented Psychemedics from assuming control of the defense of those cases. Now, those assertions have no record cites because there is nowhere in the record that that can be found. That is not the case.
Counsel, may I interrupt you for a moment?
Of course. Bearing
that in mind, Psychemedics says that if it wins its first issue, the rest of the case is moot. Do you agree with that?
Well, I do not, for the reason around the claims, the counterclaim and the affirmative defense that the city had under Article 8.2 of the contract. I'll touch on that issue since you've asked about it, Your Honor.
Well, and do you dispute it in your brief? Is it argued in your brief?
Oh, yes.
The mootness issue? Okay, thank you.
Yes, and I'll come back to that. I do want to touch on that. But the issue that was dealt with by Judge Kaplan was the 7.3 indemnification provision. And what happened is that the city in 2006 goes to Psychemedics and says, look, we've been sued. We want you to share in the cost of defending the city. Psychemedics writes a letter and says, no, we're not going to do that. Then the Corporation Counsel, Bill Sinnott, writes a letter and he says, he quotes section 7.3, the indemnification provision, says, look, you have this obligation under this. We want you to reconsider and we want you to provide financial support for the defense of the city. And then in-house counsel, Mr. Thistle for Psychemedics, writes back and he says no, but he goes beyond that. He says that under 7.3, Psychemedics has no obligation whatsoever unless and until there's been an adjudication that Psychemedics was negligent or responsible. That's wrong, but that was the position of Psychemedics. Now, the question then becomes, under this court's decisions, does that interaction between the parties relieve Psychemedics?
Can I ask you a question? Can I ask a question? Doesn't the first question become what does the contract provide? And isn't there some ambiguity in what the contract provides? And if there is ambiguity, why isn't there no discussion about who it is that was responsible for drafting this language? The history of this provision. There's nothing in any of the briefs about this. I don't understand that.
I didn't quite hear all that. I don't know if my sound is
okay. I'm on audio. I'm on phone audio for technical reasons. Anyway, let me get really close to my phone when I talk to you. Can you hear me now?
Thank you, Justice Lang. Yes, I can.
Okay. So the question I was asking has to do with the first question has to be what does 7.3 provide? And even the judge was a little confused about what it was that the language in there was. And if that's true, if it's not particularly unambiguous, don't we have to look to something outside of it, like the history of drafting and what it was that the parties intended and all that stuff doesn't seem to be in these briefs?
Well, I would submit, Your Honor, that it's not ambiguous, that it's an indemnification provision. It says that Psychemedics shall assume the defense and hold the city harmless from any claims asserted arising from the negligent or wrongful conduct. So I don't see any ambiguity in that. The issue that was joined below was that interaction that I just described, most of which is in writing, did it relieve Psychemedics of that contractual obligation to indemnify?
Well,
And I would
that constitute a demand under the clause, under 7.3. Did it constitute demand for the assumption of the defense? When you ask somebody to pay for part of the defense, it's not the same thing, is it?
Again, as we state in our brief, no demand or request is required. The trustees of New York case is explicit about that.
If you want to call for somebody to defend under the provisions of 7.3, you have to understand what 7.3 provides. Doesn't it say that they're to take over the defense? Not to take over part of paying for you to do the defense. That's not what the contract provides.
I'm struggling with your audio, Judge, but the short answer, Your Honor, is that under Trustees of New York, which is the most recent case, there is no requirement of demand or request. What is required is merely, that's a word this court used, merely notice and the opportunity to defend. There's no dispute about notice about these claims.
Listen, you can't defend this case. We're going to defend this case. You know, get off of it. We're gonna do this. They should have done that.
I apologize. I don't know if anyone else can hear Justice Lenk, but I can't.
I'm sorry. Can you hear me? Can anyone else hear me?
You're hard to hear. You're talking very
Hard to hear.
quickly and far from the microphone. So a little closer.
Okay. Well, I'm not far from the microphone. I just don't have a. I have to talk into the phone because I'm on phone. I'm on audio, according to the technical people here. Can you hear me now?
Yes.
Can you hear me, Mr. Fitzpatrick? Can you hear me?
Yes.
Okay. My question really had to do with whether or not, what was it that Psychemedics was supposed to do at that point? You tell them notice and you say, pay for part of it, and they say no. What were they supposed to do then? They're supposed to say yes, they're supposed to take over the defense and tell you to get off this?
That's precisely right. The language is Psychemedics shall assume the defense. Psychemedics chose a different path. It chose to say,
suppose, but I mean, did they know that I guess the question is, did they know that the path that you're suggesting was open to them? Did they even know that path was open? Because you never asked them to do that. You asked them to pay for part of the defense. You never asked them to take over the defense.
No, and we're not required to. That's what Trustees of New York says. All that's required.
Don't you go one step further, Mr. Fitzpatrick? Can I read you exactly what Mr. Sinnott wrote? The city requests that you share in the cost of defending this suit is a reasonable one in light of the alternative remedy provided for in the contract. So is the city expressly taking itself outside of that contractual remedy when it asks them to take a different approach?
I don't think they are. What the city, it's very clear the request that was made was that Psychemedics, consistent with its duty to defend, provide financial support for an attorney to represent the city. And Psychemedics' response was consistently no attempt to take over the defense, no attempt to say, look, it's our obligation, we're going to pick the attorney. And what I would submit is that if you compare it with Trustees of New York, the most recent case, all that happened in Trustees of New York is that the indemnity said, we believe the circumstances would make you liable under the contract. That's what Sinnott said. And then requested that they refer it to their insurance carrier. There was no request, no demand, none of these things that Psychemedics insist that we had to do. And yet this court said that provided the opportunity to defend. And also, Pasquale and Bowditch tell us that the opportunity to defend is implied, whereas here the contractual obligation to indemnify is explicit. And the obligation to indemnify in 7.3 is explicit. You shall do it. And the other thing I would say about these cases that's very important, I submit, is that the response of the indemnitor is very relevant to analyzing whether the opportunity to defend was present. And in both Pasquale and Bowditch, the indemnitor responded much like Psychemedics by saying, not our problem, we're not gonna step up. And what this court said in those cases is that that response implies that the indemnitor received all of the notice and opportunity to defend that is required. So I would submit.
Could I just go back to your more straightforward argument that you touched on for a moment at the beginning of your argument, which is that independent of the indemnification clause, that you believe that under 8.2, once the general counsel for the city wrote the letter, hey, sharing the expenses, that there was a duty to do so?
Yeah, the issue about 8.2, so 7.3 is an indemnification provision. 8.2 is a broader contractual provision which makes Psychemedics contractually responsible for any damages incurred by the city as a consequence of their negligent or wrongful conduct. Now, in our answer and counterclaim, we separately referenced 8.2 9 times. It appears in 2 block quotes with the whole section quoted. It is the basis of our 9th affirmative defense, and the counterclaim specifically alleges that Psychemedics had breached Article 8.2, in addition to the allegation that they breached 7.3. And when we got to the summary judgment stage, the motion for summary judgment of Psychemedics completely ignored 8.2, focused solely on the indemnification provision. And in our opposition, which is in the record, we again cited with specific reference to 8.2, quoted the language of 8.2, and specifically said that the city's rights and claim under 8.2, quote, precludes summary judgment for Psychemedics. That was in our opposition to summary judgment. And when Judge Kaplan, who was an excellent and very thoughtful judge, for whatever reason, simply missed that and basically said, I've resolved 7.3, that moots everything else. Well, it didn't moot everything else. The suggestion has been made by my brother that somehow we're raising this for the first time on appeal. It's 9 times in the answer and counterclaim. It's in the summary judgment opposition. It was error for Judge Kaplan to simply say that that claim is gone. There was never any analysis by him, or even an argument by the other side that claim wasn't valid. So,
so let me interrupt you here for a second, if I could, Mr. Fitzpatrick. Can you hear me now? Can you hear me?
Yes.
Okay, Mr. Fitzpatrick, let me ask you this: if we think that you're wrong about 7.3 or the indemnification clause, but think you may be right about 8 point something or other, having to do with not having been properly thrown out, what are we to do then? What is the solution then?
Well, if you were to conclude
that, do we do that as a question of law, or do we do that as a question of fact? Is that a question of law, or is that a question of fact afterwards to be resolved by the trial court, or do we resolve that?
Well, I think you would remand it to the trial court for trial on the issue of whether they've breached that provision and whether we've incurred damages proximately caused. As you know, Psychemedics, we disagree, but Psychemedics thinks there's a proximate cause issue in this case. So I would think this would be remanded for trial on a claim that was pled, adequately pled, and has a sound basis in the facts of the case.
Okay.
So just to touch upon the proximate cause issue, there were 3 grounds for summary judgment raised below that the Superior Court never reached. They've been brought up again here. I'll just touch on them very quickly. There's this theory of what we call an imagined original cooperation agreement. It cannot be found in the record. It didn't happen. It didn't exist. It fails for a whole host of reasons. One is there was no consideration for this. 2 is it's not in writing. Cities with contracts with the city have to be in writing. And there clearly was no intentional waiver of the city's contractual rights. On proximate cause, they do not dispute negligence. And they're saying that there's some intervening event that proximate cause. These people were hired because the
Mr.
police
Fitzpatrick,
department has a drug-free policy.
Mr. Fitzpatrick, isn't Mr. Bajati's going to get up there and say that they contest negligence, right? I mean, are you really arguing that they're not going to contest negligence?
I'm arguing that they did not contest it in the summary judgment proceedings. They can contest it if we remand for a trial. They haven't waived that, but at summary judgment, they did not contest it, and they don't contest it in their brief here. And we've set forth in our brief why they were negligent. And lastly, if I may, I know I'm over, but judicial estoppel does not apply unless the party has succeeded in persuading a tribunal of its position. The city has yet to do that. We lost as to those 6 officers in the Civil Service Commission, and the Ronnie Jones Title VII case is still pending in the District of Mass. And we have yet to convince, we're hopeful that we can, but we've yet to convince Judge Woodlock that there are no false positives that have a disparate impact on race. So there's no application of judicial estoppel here. Thank you very much, unless there are any more questions.
No, thank you, Mr. Fitzpatrick. I will turn to Mr. Biagiotti for the next argument.
Good morning. May it please the court. I'm Peter Biagiotti for Psychemedics. With me on the brief is my colleague Joel Rothman, and I respectfully submit that the summary that you just heard from Mr. Fitzpatrick on the controlling law with regard to notice and opportunity to defend defies over 100 years of precedent. He said that there is, quote, no demand or request to defend required. And this court, since Bradley in 1898, has said precisely the opposite. It has said that the prospective indemnity cannot insist upon retaining control of the defense. Instead,
When did they insist on retaining control of the defense? When did they insist on that?
they insisted on that.
When did they insist on defending?
Well, they insisted on it from the outset in that what must have been oral communications with Chief Fox, but clearly affirmed it when the city's corporation counsel writes that letter in June of 2006. And as Judge Kaplan spot on noted, not only does the city raise the shall assume the defense of language, it calculatedly leverages that right. And instead
Yeah, but wait a second. You know, I know historically it was that your side put up this defense saying we're not bound by this indemnification clause because, after all, you know, that only would come into account after we've in fact been found negligent. We haven't been found negligent, so it doesn't apply to us. So you're taking that position, and they come back with this view of, okay, well, let's split the cost of this then. And then this is not really any of these cases. This is not really any of the cases that you're citing to us. It's really sort of like everybody's being very cute here.
Oh, no, I think that the action by the city falls squarely within the ambit of these cases, Your Honor, because
which case controls do you think?
Bradley, Bowditch, Pasquale, all of them, what they all say is that the words of the prospective indemnity must make clear implicitly or by the words that they are allowing the opportunity to defend, they are calling upon the indemnitor to defend, and most importantly, that the second requirement is that the prospective indemnity must surrender control of the defense. That never happened here, even by the time of the letter. Even by the time of the letter in 2006, the city already had retained outside counsel, answered the complaint, removed to federal court, eschewed a motion to dismiss, asserted 20 affirmative defenses, admitted to 25 facts, and was clearly retaining control. If you read the letter from Psychemedics in response, Psychemedics acknowledges that Psychemedics has already been assisting the city since 2004 with regard to these kinds of claims by meeting with the city's outside counsel. And if that
Haven't
were
you already at this point, though, I mean, in 2006, haven't you already told the other side that told the city that you're in fact not bound by this indemnification agreement because the preconditions of it have not been met? Haven't you already told them that? I know it's not a position you take now, but at the time, historically, you did.
Psychemedics in-house counsel read what I agree, Your Honor, is an unclear provision. He read it in a very aggressive way. He said that because it applied only to claims arising out of wrongful acts or negligence, that the wrongful act or negligence had to be first established.
Right, that's right. And
Yeah,
so, I mean,
but-
he's taking a view of the contract that was different than the view that the city took. And he's saying, no, we don't have an obligation to defend you, right?
Very much so. And what was the city's response? Because it's telling. It's telling. Did the city, for example, sue because Psychemedics allegedly had breached in 2006 its obligation to assume the defense? No. What the city did instead was accept 20 years worth of assistance, legal and technical, from Psychemedics. And in fact, by 2009, the outside lawyer for the city, in an affidavit to the federal district court on an issue of privilege, affirmed that assistance was, in her words, pursuant to a continuing agreement between Psychemedics and the city. Finally, very telling. In 2007, the city chooses to attempt to obtain leave to assert a third-party complaint against Psychemedics in the federal case. And if you look at that pleading, it's in the appendix, the city acknowledges there that Psychemedics knows its science, and so it ought to have the opportunity to participate in this case, quote, as a party. So the city is affirming time and time again by its calculated strategy and by its acceptance of 20 years worth of assistance that it is.
Well, I understand that, but I'm just saying, I think in terms of just trying to figure out what's going on in terms of the clause itself. I mean, are you agreeing with me that it's an ambiguous clause?
Well, I think that ultimately that Judge Kaplan's reading was correct. That because even though it does say claims arising from any wrongful or negligent act, it does make clear that it's claims as well as suits. And so there would be an obligation if the prerequisites of Bradley and its litany were met to assume, but only if.
Who drafted this language? Do we know who drafted the language?
Well, the language is part of it derives from a boilerplate contract of the city. There was an amendment to it which added wrongful or negligent acts or omissions, but it was bargained for between.
But that doesn't affect this analysis, right? That's the later amendment does not affect this analysis, right?
It doesn't at all. What's important to the
Right,
analysis is whether or not the city, by its words, called upon Psychemedics to come in and defend. The Riva case is the most recent, 2013 federal district court case in Massachusetts, but it's a very apt summary of the Bradley, Bowditch, and Pasquale line. And what the court in Riva said was failure to allow the indemnitor to take charge of the defense relieves the indemnitor of its obligation to indemnify. Here,
what does it say though in terms of what the indemnity has to do in order to get that going? What does it have to do? Does it have to say, "I'm sorry, we're going to keep the defense here, and too bad, we want you to pay for it, and so it's all your fault, and later on you can pay for it all if we lose the trial," or is it something more than that? Is it something that they have to say, no, we're perfectly willing to hand it over to you, but they have to do anything affirmative? Do the cases require them to do anything affirmative in that regard? What do the cases require them to do?
the indemnity.
Yeah.
Yes. Well, I
I'm
think
sorry. Let's just I hate those language. I hate the in T and Tor
city,
stuff.
the city.
Let's say psychometrics and the city. What does the city have to do? What does the city have to do in these circumstances? What does the case say the city had to do in these circumstances?
The city has to do three things. The city has to give notice to
Okay, that happened.
Psychemedics. That happened. The city then has to, in some form of words, call upon Psychemedics to come in and defend. And finally, the city must, in the words of the cases, surrender control of the defense. It must allow
Okay, let me just ask you, okay, surrender control of defense. Okay, let me ask you the question. Suppose that the city had just said, pursuant to 7.3, you have an obligation, okay, how about this? City says to the psychometrics, you have an obligation under 7.3. Please do the necessary. Is that enough?
I missed the end. Please do. You have an obligation. Please do what?
The necessary.
Please do what's necessary.
The necessary. Yes.
Please do what's necessary. Yes, if there was a specific invocation of 7.3, and they said, please do what's necessary, that would be closer, at least. Judge Kaplan was right when he said the Pasquale case is a great illustration of what the bare minimum is that the indemnity, the city, would have to do. And in that case,
can you shift to the second provision? Because I don't understand why the judge dismissed the second provision. It's got to provide something in addition. So tell me, 8.2 says if the damages sustained by the city resulting from Psychemedics' wrongful or negligent acts or omission exceeds sum due or to become due, Psychemedics shall pay the difference to the city.
yes.
So doesn't it still remain in the case? I don't understand why that goes away.
Two reasons, Your Honor. The first one is the one that Judge Kaplan cited, which was that the city never disputed our position that if we won on notice, then the counterclaim was mooted. And just very briefly on that, and then I'll turn to the trust.
I'm confused by that. Just makes no sense to me. So better flesh that out a bit, because I personally agree with your argument on the first issue, that the city wanted its cake and wanted to eat it too. They want to defend it. They want to control it. And particularly, although I understand why they do that, particularly because your assistant general counsel tells them, we don't have to indemnify you until the case is over, which seems to me, as you put it, aggressive. I would put wrong. But then I see that, okay, so they took over, now they've lost. And they may have lost big here, or I don't know if negligence or wrongful stuff has been proven yet, although our own decision raises some question about that. Our own previous decision involving this testing. So why isn't the second provision out there? And if they prove that you were negligent, they get to recover the difference between what they paid you and the damages, or whatever the calculation is. Judge Kaplan is very sophisticated. I understand the first part, but I don't understand the second part. And it was just a footnote, right?
In the opinion, yes, although what we argued below, and what I would turn to now, Your Honor, is that not only was it not raised below, and again, just briefly on that, I do respectfully urge you to read the passage that Mr. Fitzpatrick talked about. When 8.2 was raised in below, it was only in the context of whether or not the city had waived such a right, not with regard to its counterclaim. And in fact, in that passage, it ends with, for that reason, that argument precludes summary judgment for Psychemedics. So it was raised with regard to why Psychemedics should lose, not with regard to why counterclaims should endure, but more specifically to your point, Your Honor. Section 8.2 can be read in harmony with Section 7.3, which is far more specific. So 8.2 takes care of claims directly by the city against Psychemedics for example, a late delivery of tests or an incomplete delivery of tests. And that's why you see that language about if that late delivery causes damages that exceed the sum due or to become due.
Well,
So,
that's a really narrow reading of that provision. Why isn't the reading is if your tests are negligent and we get sued by a bunch of officers, and we have to pay them more than the, whatever the differential is, you got to pick this up. Now, maybe the answer is if you defended and lost, meaning you didn't let us do it and you blew it, maybe we don't have to do it. But that's not the argument from what I understand. Or is it? Is that the argument?
Very briefly, because I know I'm coming up on time, two things there. First of all,
Justice Gazzano was very generous on time. You'll be fine.
Thank you. And I am going to get to a bit on the merits of the test, which I know you're particularly interested in. But back to contractual construction. The broader phrase in 8.2 has to give way to the narrower and more specific 7.3 in the instance of claims brought by third parties. That's why 7.3 is there. If you read 8.2, which my brother rightly describes as a broader provision, if you read it to swallow up 7.3, then you're rendering useless 7.3 in the very specific instance that it's meant to control on. Finally, that provision, you're right, only kicks in if there are wrongful and negligent acts by Psychemedics that cause injury to the city. And that has not happened here. The city prevailed in the federal court twice on summary judgment. There's a remand, but it's only on the question of whether or not using the hair test plus a follow-up urine test is a less discriminatory alternative. As the city's lawyer just 15 months ago argued to this court in the Gannon case, the First Circuit has affirmed the reliability of the test. It's the city's counsel's words. And as she also made clear at the time, and we agree, in the Civil Service Commission, the Civil Service Commission affirmed that the test may be used to create a rebuttable presumption of ingestion. And so the Psychemedics test has prevailed in terms of delivering what the city bargained for in every single litigation.
I know I said that, but I was all alone. So I'm not sure the majority will agree with you on that, but I leave that for another day.
Any further questions? Thank you, Mr. Piagetti.
Thank you.
I'm sorry, Justice Link, did you have a question? You're on mute. There you go.
Technology. Can you hear me now? Can
Yes.
you hear me? Okay, good. That was my question. Okay. Mr. Piagetti, I wanted to ask you the same question I asked your brother before, which was, suppose we agree with you on the indemnification provision, but we disagree that that it dealt with 8.2. What do we have? What happens now? Are we supposed to construe the meaning of that paragraph and say, okay, on the facts here, you win, or are we supposed to send it back to the court for further proceedings? Because it seems to me that there too, we don't have any information about whether it was that with the history of this clause that apparently you're disagreeing about what it means, 8.2. And we don't have anything in there about the history of the negotiations of the parties or who drafted it or anything like that. And we don't have any information about of course, that's also true that I don't see anything in the briefs about any outside of Massachusetts cases on these subjects. But that's another point entirely. But I mean, I really was curious about what you think should happen if we disagree with you about whether or not necessarily they waived that.
Well, you, as Your Honor knows, this court may affirm on any ground that was raised below. So even if you were to find that 8.2 applies in that broad way, and again, we say that 7.3 trumps it, you still have two other grounds on which to affirm the summary judgment, namely that by its conduct, the city waived any right to indemnification.
Yeah,
And
suppose we
secondly,
don't buy your other reasons. I guess that's what I'm saying. If we don't buy those reasons about estoppel and so forth and so on, and we just say, no, the judge got it wrong because in fact they never waived this, they never waived the 8.2 argument, and it's still before. Do we have to send it back to the judge for trial?
I still don't believe so, respectfully, Honor, because if I hear you correctly, if you agree that Judge Kaplan was correct with regard to the Section 7.3 failure on the city's behalf, then the city has forfeited its right to indemnification under a more specific and more squarely applicable clause of the contract. And so Psychemedics is still entitled to summary judgment.
Okay, thanks.
Anything? Okay.
Okay, that's it.
All right. Thank you, counsel.
Thank you.